Connor, may I inquire whether there's a time limit of any kind?
I'm sorry?
Is there a time limit on these cases? I'm just not sure what the time limits are.
20 minutes aside, and I'm saving you 5 minutes for rebuttal.
20 minutes, I'm sorry.
Yeah.
Yes, sir.
You, Mr. Chase?
Yes, sir. Stephen Turner from the appellates.
Okay.
From Tallahassee, thank you.
Before you start, I have the impression that maybe Mr. Chmielewski has died. Is
Yes,
that
sir.
correct? Are there plans to substitute a PR, or
Yes,
what
sir.
do we?
We will substitute a PR. Mrs. Chmielewski, of course, is still
Right,
in the case.
right.
And Ms. Weingarten, who actually initiated the request, is here at the council table.
Okay.
All right, sir. At issue today, Your Honors, is whether shade minutes of a city commission meeting to discuss strategy and settlement of a pending quiet title suit against the city must be disclosed once that litigation is concluded by final agreed judgment. The plaintiff appellants argued their motion for summary judgment in this public records case at a duly noticed hearing, but the trial court dismissed the complaint with prejudice, ruling that the 2006 quiet title action continued when the same plaintiffs brought another suit a year and a half later, claiming damages in relation to property that had been involved in the quiet title case.
What we can't tell, because I think the conclusion of the first lawsuit, we are having difficulty finding the underlying agreement, but it seems that when the first lawsuit was resolved,
Yes, sir.
hanging in the air remained the question as to how one defines the scope of the easement across the property. If that's accurate, to some extent, does the lawsuit sort of remain in hanging out there to some degree?
No, sir. There's no dispute about the scope of the easement. I think there may be some lack of understanding. I think the city.
So that's what caused the second lawsuit.
Oh no, sir. The second lawsuit is a taking claim.
Because the general public, St. Pete was letting everybody who was using
Yes,
that
sir.
property traipse over the feet.
On the beach property and
Right.
the damage, of course, to the homestead, the home parcel.
Right.
But yes, but it's not a matter of an easement. The city didn't claim an easement. There was no easement being claimed in the quiet title
I'm
action.
being inarticulate of what I'm
Yes,
calling,
sir.
but there is an issue
Yes, sir.
that I guess existed at the time of the first lawsuit that for whatever reason did not get encapsulated in that settlement.
There was a defense raised by the city that they owned, it's my understanding, that they owned property in a residential subdivision, and it was because they owned this property, they had a right to use the same as any member of the subdivision. That was resolved by the final judgment and by the mediated settlement, which was part of the final judgment, where they acknowledged and agreed that the general public, by virtue of their ownership of the property in the subdivision, did not have the right of use. And it couldn't be clearer. I couldn't articulate it. I don't think this court could work harder to come up with more clear provision in that settlement agreement where they agreed that defense was gone. Now that we've instituted a taking action, which, by the way, this is only a small part of, they may raise as a defense, or in other words, we may come in and show that they've already agreed that the public can't come on the property, or we may just prove the public's coming on our property. It doesn't matter. What they're challenging really here is they're really trying to undo the collateral estoppel effect of our position before we've even asserted it really in the takings
But
case.
The takings action is a third action, separate
Absolutely.
and distinct from all of these. Is that right?
I'm sorry, before I didn't hear you. You're right.
It's separate and distinct from the public records
Oh, yes.
proceeding that's here. All right.
Yes, that's another, in other words, we had the quiet title suit that was brought in '06. It was settled in '08. Then a year and a half later, a takings case was brought, not only with respect to the quiet title, which you had to have as an underpinning, but all of the conduct, a course of conduct over many, many years is the basis for this quiet title suit. I mean, for the takings claim.
Jack, back to Judge LaRosa's first comment. The agreement does not appear to be attached to the copy of the stipulated final judgment in our record. Is the agreement between the parties that resolved the first lawsuit someplace in this record?
It should be, Your Honor. I believe it's in the motion. I will look during my break here and see if I can't find it for you. I think it's attached to the maybe to the summary judgment motion, or it's in the record somewhere, but it's part of the final judgment.
Okay.
It was adopted as part of the final judgment. And my point,
It is the case, the shade meeting for the first lawsuit.
Yes, sir.
All we're talking about is who owns that property.
That was the quiet title suit.
Ownership, the quiet
Yes.
title.
yes, sir. In other words, we had to establish our ownership because the city challenged that we owned the beachfront parcel. And that was a condition. We had to get that done before we could go into the other things. So our point, back to my point of the status of the procedure, is that because the record establishes here that the quiet title case was concluded by a final judgment, and we have negated, and we negated in the record, the city's exemption claimed under 286-0118, the appellant asked the court here to reverse the decision below for the city and to direct entry of judgment in their favor and to direct that the required production of the shade minutes at issue be made. This public records case has been pending almost 2 years, and the shade minutes regarding the quiet title litigation before its conclusion by final judgment should be made available consistent with Florida's strong public policy, reiterated by Amicus Freedom Foundation, by the way, which requires prompt disclosure of public records.
I'm assuming that any concerned citizen on the day after first lawsuit is concluded could have made a request for the shade meeting minutes?
I believe you have to wait till the judgment became final. I believe
Okay.
that's the exact way the Attorney General has interpreted
So
this.
the next day after the final judgment
Yes.
becomes final? Okay.
Once it becomes final, it is open to do it. And the fact that there is related litigation, subsequent related litigation, has been addressed by several authorities, and the unanimous position of the Attorney General, who is obviously the interpreter of this law for the cities and counties and other districts, has made very clear that, and to quote from Attorney General Opinion 0925, an action or suit is pending from its inception until rendition of the final judgment. And over and over, the Attorney General has ruled on this. You can't hide the ball. Once the final judgment's over, it's over. The case is concluded. Once negotiations have occurred and you have a contract, the negotiations are over. And the fact that there's a subsequent lawsuit doesn't change that the negotiations are over. So that's the idea of what was going on here. The Coca-Cola.
Let me go back, if I may. Does it tell me why or why not does it make a difference when we have what appears to be an unresolved and likely to be disputed issue as to the right of people to cross that property?
We don't have an unresolved decision. First of all, it was addressed as their defense in the case. So you don't have the.
And there's something in the agreement that says the owners of the property retain the right to cross.
There's the mediated settlement agreement,
Right.
which was part of the final judgment, which was made part of the final judgment to take care of the defenses asserted by the city then, that said the ownership of the city of the Art Center, which is a lot in the residential subdivision that they by quirk have gotten title to, which said that does not give the right of the public to access our property. That's the only provision that addressed it. If there's any claim or defense of the city that it had a right of some kind to go on this property or allow the public to come on this property, that's a defense to the taking case. And they can assert it as a defense to the taking case. And they have asserted as a defense to the taking case. Now, we may have collateral estoppel problems. They may have collateral estoppel problems. But that's on any judgment. The judgment is no less final because it is relied upon in another case. It's still final. And the litigation has been concluded by the judgment, which is then brought or relied upon in a subsequent case.
Remind me of what reservations, if any, did the trial court maintain in that first lawsuit?
The standard jurisdiction to enforce a judgment, which would be in any judgment. If somebody were to try to come in and say, Judge, we want to enforce our title, or they're coming in, you could go back to the other court.
But nothing that necessarily anticipates further litigation.
No, sir. And by the way, the reservation of jurisdiction, or the fact that you come back on a motion to enforce, that doesn't make the judgment less final. One of the cases that was involved, or one of the cases here involved, said a motion for attorney's fees, for example, coming in. That's not altered the finality of the judgment. So you can't withhold these shade minutes under the Attorney General's opinion that was rendered in, I believe it was the 2012 decision of December 13, 2012, where the cases said that. So the fact that you have related litigation, or any problems that may connect it to this litigation, which is what the trial court thought about, and it's really another way of what the appellee is arguing. This has been addressed, the Seminole versus Wood case in the 5th District in '97. That case said the fact that you've got subsequent or additional litigation regarding the same property, the equipment, that doesn't change it. That doesn't change it for purposes of conclusiveness of litigation in a much broader exemption under 119. I've said reference to Coca-Cola Bottling Company, where the state's saying, don't make us disclose what we talked about when settling with one, when we have to sue another one dealing with the same kind of an action. The Attorney General's opinion in 2013, the 1313 decision, says the fact that you've got a derivative claim is brought, a new derivative claim coming out of the same cause of action that you've settled and a judgment's gotten on. That doesn't change the finality of that formal litigation. The statute, as the Attorney General's opinion quotes at the end, the statute does not recognize a continuation of the exemption for derivative claims made in a separate subsequent litigation. And this office cannot read such an exemption into the statute. These are strictly construed, narrowly construed. This is the narrowest of all the exemptions, and it is narrowly construed in favor of the part of the public to see the document. It is not consequential that a post-judgment dispute, as I alluded to earlier, arises out of the judgment that you've had, or out of the formal litigation. That doesn't reenact or reconstitute the litigation. You're going to have disputes about a judgment. A judgment, as I say, is pretty much a contract. It's a public contract, and it's enforceable. And you can take that and go and sue on it, or you can rely on it any way you want to. And there are all kinds of defenses that can be asserted. You can attack the meaning of the judgment. You can attack its extent of its enforcement. But that is other litigation for another day. It is not the litigation that has been concluded. As I say, the really good decision on this is from this court is in Freeman, the 696 Southern 2nd in 1997, where the court said you can't conduct post-judgment meetings about the judgment and call them protected. They're not protected. You have to end the litigation and go from there. The Coco case of the Supreme Court, before amendment to the statute, dealt with another part of the 119 exemption and said in the criminal context, these post-judgment motions, once you've sentenced it, the defendant, the litigation is concluded, and post-judgment relief motions are not an extension of the litigation, or extension of the privilege. Your Honor, I believe I've money.
Okay.
Thank you.
Thank you.
May it please the court, my name is Ellie Nyberger. At council table is Susan Cheruti, and also present is Mike Davis, and who's the city attorney, and also Zachary Margot, who's a summer law clerk at our firm, and we represent the city of St. Pete Beach. I'd like to start by...
Would you agree that after the judgment became final, any concerned citizen could have asked for it and received the shade meeting transcripts?
There's a question in this case that I don't think needs to be answered, which is at what point, how many days after the judgment became final, the appeal period expired, would it have been concluded for purposes of the shade exception. I don't think that was reached in this particular case. This case left the issue open, and I'll read you from the mediation agreement. In the event of an ambiguity regarding the meaning of this agreement, the parties agree to submit such issues to the mediator for a further mediation conference. That's paragraph 6 of the
That's different than just reserving, that's no different than I'm going back to the court for some enforcement action or some resolution of an ambiguity. That does not affect the finality of the judgment.
Well, the finality of the judgment is different from upon conclusion of the litigation for purposes of the shade exemption.
So there may be an issue of ambiguity that's going to arise 20 years hence, and therefore no one's going to get the shade meeting minutes?
Well, I don't think that that's something that would have to be necessarily decided in this case, how far out it has to go. The issue here is that the Chmielewskis requested a copy of the shade meeting that discussed, where the city discussed its private settlement strategy with its attorneys before the first mediation in the 2006 taking case. They requested that after the trial court in the 2006 case, the same exact one with the same exact case number, ordered the parties to return to mediation.
The final judgment, which was entered on November 26th, dismissed with prejudice the Chmielewski's cause of action and reserved jurisdiction to enforce a new contract, a new agreement, basically. And this order, as I understand it, was not appealed. Is that right?
That's correct.
Okay. So in January of 2009, if I had made a public record request to the city of St. Petersburg to see this transcript, I would have been entitled to receive it, wouldn't I?
I don't believe in this particular case that's correct. And that's not to say that
kind of is the critical issue here. Why not?
Because the mediation agreement contemplated continuing settlement on the merits of the actual dispute.
The actual dispute was a cause of action dismissed with prejudice. It was gone by January.
It was dismissed with prejudice, subject to the court's ongoing jurisdiction to send the parties back to mediation to continue to resolve
the issue. I haven't read the agreement, but reading the judgment itself as a member of the public, just looking at public record, the cause of action is gone. There may be some new claims on a new agreement that would be a contract to enforce or interpret, but the subject matter of this lawsuit is over, isn't it, by January of 2009?
No, I would disagree there, because the central issue that did in fact come up again was what are the city's rights to use the property versus the Chmielewski's rights to use the property. That ambiguity in the term the general public in the mediation agreement, which said that the city had the right to continue to use the property subject as allowed in a plat dedication reserved to all property owners in the subdivision, but that plat dedication did not allow the city to then allow the general public access to the beach.
So how long was it going to take to interpret or enforce or resolve this agreement?
Well, we found out just a year later, the Chmielewskis filed another lawsuit.
What if they didn't?
Well, I think the issue that is...
In other words, when do you admit that a member of the public categorically was entitled to get a copy of the shade agreement?
In this case, it has not happened yet. In other cases, I think that it's, when the city can release the transcript without the fear that their private discussions are going to be used in the same exact litigation. And we see this in cases where cases are dismissed.
It can't be used in the same exact litigation because the court dismissed this litigation with prejudice.
But subject to its authority to return the parties to mediation to continue working on the same exact mediation agreement.
You don't think the cause of action was really dismissed with prejudice?
It was dismissed with prejudice, subject to...
But the city was in the best position to protect itself if it thought this was an ongoing piece of litigation. It could have proposed a final judgment that kept this issue alive, because it sounds as though everybody was anticipating there's going to be a takings issue. And if that was what was anticipated, the city could have protected itself.
Well, I don't necessarily know if that's what the city anticipated, the takings claim. But the parties did anticipate that there would be disputes that would have to be resolved in further mediation, and that's what they did when they entered this mediation agreement. And I will just go back.
But the quiet title action is done. It's gone. Correct?
It's done subject to the parties' ability to go back and resolve the ambiguity of what are the city's actual rights as a property owner to use the beachfront property, and that's an ongoing issue. And I the city did not reach the point where this litigation was actually over. What the Chmielewskis did was they requested a copy of the transcript discussing their pre-first mediation strategy, settlement strategy, and thought that they could request it and they were entitled to it before the second mediation in the exact same case. I think that's really important. They're continuing the same mediation. They're forced to ordered to continue the same exact mediation, and that's the point where the Chmielewskis requested the shade meeting transcript. So basically what they're arguing is that the city's settlement discussions with its attorneys before the first part of mediation, those are private. They agree those are private. But now, because there's a judgment, even though there's a second mediation coming, now we're entitled to get those. We're entitled to know those private discussions.
Help me out. Is a second mediation under the case number for case 1?
Yes, Your Honor. It's in the 2006 case, the same case number.
But it is in relation to the scope of what general public means in terms of traversing the property, right?
Yes. Yes, Your Honor.
So it arises really because of the claims asserted in lawsuit 2, the takings case.
The takings case prompted the city to file a motion to enforce the mediation agreement, which requires the parties to go back to mediation to decide that issue of what's the general public. Because in the takings case, the Chmielewskis were saying that the city's use, long-time use, constituted a taking by allowing the general public. So the city went back to the court in the 2006 case and said, please enforce this mediation agreement that says we need to go back to resolve this in mediation.
Whatever the city's concerns are about the release of the shade transcript, are there not procedures or protections that the trial court could put in place to minimize any risk or downside that the disclosure produces?
In the public records context?
Yeah.
The one option.
If you get the shade transcript, are there procedures or protections that the trial court in lawsuit 2 could impose that would ameliorate any concerns you have about its disclosure?
I don't think so in the public record, with respect to public records, because if they're disclosed unredacted, then they're disclosed. If they're filed with the court, they're released to the public. The city is opposed to releasing the shade meeting transcript to the public at this point. The court could do, maybe they can be filed under seal, but.
Or you can't use certain information at your trial or something. I don't know. I'm just wondering.
Right. Are you talking about in the takings case?
Yes.
Well, I don't see how it matters whether or not the Chmielewskis could use the shade meeting transcripts in evidence if they're just private attorney-client discussions that they aren't entitled to. I mean, I think it's putting the cart before the horse. They're not allowed to use those shade meeting discussions in evidence because they're not allowed to know what they are. So it is important that these are the exact same case. It's not nearly the same case. It's not substantially identical. They're the exact same case.
Counsel.
Yes.
Confirm for me the first case is a quiet title action, no counterclaims.
That's correct. It was a quiet title action. It was in 2006. The takings case was in 2009, and then the public records action was filed in 2012.
But there are no counterclaims in the quiet title action.
No, Your Honor.
And the second case is an inverse condemnation case.
Yes, Your Honor, the 2009 case.
And why would a quiet title action and an inverse condemnation case be the same case?
They're not the same case. The 2006 takings case is the same exact case that they were ordered to return to mediation in 2011. The same case number where the November 2008 judgment was entered. In 2011, in June 2011, the trial court in the same exact 2006 case ordered the parties to return to mediation. So the cases like the Coca-Cola case that are saying no, it can't be related cases, that's not good enough, those cases don't apply. This is the identical case, quite literally, in every respect. And another important thing.
I'm sorry, the motion to send the case back to mediation was, remind me of the process, that was a result of the city's motion?
Right.
The judge in lawsuit 1.
Right. The city filed, and this is important too, the city filed a motion to enforce the mediation agreement to send the parties back to mediation. The Chmielewskis agreed, send us back to mediation. The court said, okay, entered an order sending them back to mediation, and then the Chmielewskis requested the shade meeting transcript in that same exact 2006 case. This is precisely the unfair advantage that the shade exemption is designed to prevent. The city's opponents in the same identical litigation getting their strategy discussions, and you try to then being able to use them to their advantage while this same exact case is ongoing. I would like to just briefly address the distinction between a public records exemption and the shade exemption to the Sunshine Law. They're different. The public records exemption, public records exemptions apply if there's a public record, we know it's a public record, but for some reason it's not required to be disclosed. Here, the exemption to the Sunshine Law for shade meetings says that the transcript of the shade meeting never becomes a public record at all.
The issue here is whether it ever became a public record.
Right, exactly.
Rather than whether a public record needs to be disclosed.
Right, and so that's why it's an issue of could this be dismissed on a motion to dismiss for failure to state a cause of action, because as opposed to an exemption to the exemption to the Public Records Act, which would probably have to be pled as an affirmative defense. Here, it's the Chmielewskis had to plead a public record, and on the face of their complaint, the enforcement proceedings are ongoing, and that is why the trial court correctly dismissed.
But if it was just some third-party member of the public that filed a request for this, I guess their proceeding would be to compel the city to file the document into the public records.
It would be
You're mandated to do that by virtue of the statute.
right. Yeah, if a third party wanted to file this, they could bring it as a declaratory action, or they can bring it as a petition for writ of mandamus, requiring the city to just give them the copies of the shade meeting transcripts. And that's the same thing that could happen if the city did get a public records request in the meantime, in the interim between the final judgment being entered in that kind of limbo period, is they could have brought, if somebody did request it, they could have filed a declaratory judgment action to resolve the issue, whether it ever actually became actually concluded the litigation. And then just one final point is the legislature didn't intend the shade exemption to be applied in a way that ignores the realities of litigation. This is clear. Well, first of all, the purpose of the exemption is to create a level playing field by allowing the government to have some sort of discussions with its attorneys in private about litigation. The legislative history is important in this regard because originally the statute said that the shade meeting transcripts would become a public record upon conclusion of each phase of litigation. And I listened to the committee meeting where that language was amended until upon conclusion of the litigation. And I think what's key there is that the legislature and the committee, they discussed alternatives. You know, what is in light of the purpose of this exemption, what words captures all the situations that we intend this to apply to, and it's upon conclusion of the litigation. They discussed and rejected upon entry of final judgment.
But the language about at each stage of the litigation seems to me to be the strongest language to support your position, but the legislature chose not to use that.
Well, the way that it was intended as drafted was like at the end of discovery, that kind of, baby steps throughout the trial, and then post-trial, upon conclusion of the litigation was intended to capture something more broad than each phase of the litigation. And given the number of cases where there are post-judgment enforcement proceedings, the legislature surely could have said upon entry of upon entry of final judgment or the expiration of the appeal period, but it didn't. Upon conclusion of litigation, we agree that exemptions to the Sunshine Law should be read narrowly, but they can't be read out of existence here. And this is the exact type of case where the legislature intended to protect the city's confidential attorney-client discussions. That's all I have. Thank you.
Thank you.
Thank you. Mr. Turner.
Thank you, Your Honor. I want to make it clear that the takings case is not the same identical litigation. I think the court picked up on that, but I just want to emphasize it is drastically different litigation. Damages versus adjudication of the rights to property. It's a whole different case.
Was it clear when this stipulated final judgment was entered that there were going to be continuing mediations about what was established in the agreement that I haven't been able to see yet?
I don't believe that's the way you read it. I do have a copy of it. I'm sorry that I don't have the cite to the record. It is in the document. It is attached to a document that was served on July 22nd, 2013 by the city. It's called City of St. Pete's Amended Motion to Enforce Mediation Agreement, and it attaches that mediation settlement agreement that was attached to the final judgment, which Your Honor referenced. I know you have a copy of the final judgment entered by the court dismissing the action after adjudicating the title and the right to property. That mediation, while we're on it, I might as well point out to you what it said here. That mediated settlement agreement that was part of the final judgment says the defendant, that is the city, further agrees that its ownership of the Don Vista Community Center does not give members of the public, does not give members of the general public the right to travel onto the above Block M, that's the beach parcel owned by the plaintiffs. So I don't know how you say it clear. I mean, I don't know how you do that, so there's no ambiguity. Counsel involved in the case at the time when the takings case was filed, counsel agreed to go to mediation. When the city raised this issue about, well, what does it mean, they agreed to go to mediation to satisfy that requirement, whatever it was. It doesn't say anything more than, okay, we'll mediate. If there's any dispute about this agreement, we go back to mediation. That's what it says. It doesn't say anything more than that. It does say in this agreement, as also says on page 4 of the document, except for the agreements and express obligations set forth herein, neither party waives or relinquishes any claims which either party has, now has, or hereafter acquires against the other party. So this agreement contemplated there could be further litigation between the parties. And though, as Judge LaRose points out, there's no reference or saying you got to litigate it in the context of this case or anything else. So we were perfectly free, the city agreed that we were perfectly free to go litigate somewhere else on other claims. They knew we may have another claim. But this is, what they're now contesting is what this agreement says, where they, in absolute unambiguous language, I don't know how it could be absolutely clearer, does not give the members of the general public the right to travel onto our beach property. They said it, and now they want to mediate it and somehow not let us go forward or something in this other case, or disclose what they agreed to, or what was the terms of the agreement that may have been discussed. I don't know. This is a public meeting. I'd like to say this. This is a public meeting, and under the Florida Sunshine Law, it has got to be public. There's only a narrow and limited exception, and the purpose of the exception was so that in pending litigation, you could discuss strategy and settlement. That's the extent of that exemption. They discussed strategy and settlement, they settled, and now it's over, and it should be produced. And that's the law of Florida. This is not attorney-client, this is a public meeting. And it's the only reason it's temporarily not public, available to the public, pending, because it's dealing with pending litigation. And that litigation is no longer there, and so it is no longer amicable. The fact that we held a second mediation, frankly, we'd hoped to say they would settle. We were told that they would want to settle. And later on, somehow this commission changed and they decided they didn't want to settle. So while we went to mediation, it's not a relevant issue here. It satisfies any concern, and it's behind us. There was an impasse, and we don't agree that this is ambiguous, and so in whatever it is, it's at the end. The fact is that, however, for purposes of the public meeting, that is now available to the public. As the courts observed, it was available the day after the appeal period expired. Thank you, Ron.
Thank you.